Welcome to the Addition Financial webinar, Estate Planning 101. Our speaker today, Mary Kaplan, is sharing her expertise from the Kaplan firm. Feel free to type your questions in the chat box and we will answer them during our Q&A session towards the end of the presentation. And now I'll hand it over to Mary.
Good morning, everyone. Hope everyone's enjoying their day so far. I am here with Addition Financial, and I am honored to present Estate Planning 101, where we're going to review the basics of wills, trusts, and estates in Florida. So let's go ahead and get started. Okay, here we go. And by the way, I should introduce myself a little bit first at the beginning here. My name's Mary Kaplan. I'm an attorney here in Florida. I've been licensed here in Florida for 12 years, just about. And before that, I started my career in Georgia, where I had practiced for about 11 years before I moved here. So I'm working on almost 23 years of experience. I have always focused in this area of estate planning in particular, and also probate, which is the court process that occurs after someone passes away. And I also practice in the areas of guardianship and elder law planning. So I'm happy to present today just sort of the basics, like I said, about estate planning in Florida. So first of all, here's what we're going to talk about today. Why do I need a will? We've gotten a lot of questions from a lot of you about this very question. Why do you need a will? So we're going to be talking about that. What is probate? So what is the process? And just briefly again, probate is a court process. So it is actually a court case that gets opened after someone dies in order to move whatever assets and property they own from their name to the names of their family members or charity or whoever it was that they wanted to leave their money to if they had a will. And if they don't have a will, it's to move the money and assets they had to whoever the state of Florida says should inherit those assets. Why do I need a revocable trust? We're going to talk about that. What about jointly owned property? This is a common way people try to get around probate. So we're going to talk about what that can do and what are the pros and cons of that. Powers of attorney and healthcare surrogates. These are very basic documents, but they are very important to have. So we're going to talk about those documents. Out-of-state property, we're going to touch on what happens to properties that you might own outside of the state of Florida. And then we're just going to conclude everything. So let's start with our first slide here. So why do you need a will? So there's many different reasons that you would need a will in Florida. First of all, people with minor children often are concerned about what would happen to those minor children if they passed away while one or more of them is under the age of 18. The way to address this is in your will, you would name a guardian of any minor children that you have in order to avoid a potential court battle between family members and different sides of the family who all want to be the guardian, which unfortunately has happened before. If you have older parents, some of you maybe who don't have children, maybe you're not married either, and you want to leave your money to your parents, and that's kind of what you always thought in the back of your mind that you would do. Well, they might not need or want your money, especially if they're anticipating or already in a situation where they're in an assisted living or a nursing home where they might be receiving Medicaid benefits. If you leave money to them, then immediately that money is just going to go towards Medicaid to pay for that assisted living or skilled nursing facility. And also, even if they're not in a facility, if they're, far along in life in their 80s or 90s, they're not really going to have a whole lot of use maybe for your money. So maybe you'd want to think about who else you might want to leave that money to who could use it. Revocable trusts, we're going to talk about. Even if you do need a revocable trust, which you might, wills can be used together with those revocable trusts. So even if you have a trust set up or you're thinking about doing that, you'll still need a will. They kind of work hand in hand together with trusts. And we'll talk more about that in a few minutes. If you do die without a will, that is called intestacy. So if I have no will when I die, I'm intestate. And what that means is the court will determine where your assets go. So instead of you making the decision on who receives your assets when you die, the court will make that decision. And it's basically just based on Florida law. There are laws that dictate where your assets will go if you die intestate without a will. So there's a few reasons. There's more reasons as well that I'll kind of touch on here real briefly. So basically, if you don't have a will, and we're going to look at the Florida law, that dictates where your money goes. Maybe you're okay with that. When we take a look at the next page, maybe you're going to say to yourself, I'm okay with this. I'm fine with what Florida law says on who should receive my money. But one of the problems is if you don't have a will, is that you're not going to have someone named as personal representative to head up the probate process. So you don't have a point person. So that means it's open season for anyone in your family or otherwise to petition the court to become your personal representative. So you have a potential battle between people who want to be in charge of this process, and they are entitled to pay as well for that role that they're going to be performing. And another point is that if you don't have a will, then whoever does end up being your personal representative will not be empowered to make many of the decisions that they could otherwise be empowered to make under a will. So for example, if you don't have a will and your personal representative wants to sell your house, to liquidate it and divide the sales proceeds among your heirs, they will not have that power without going to the judge and asking for that power. So that means that every time they want to do something like sell a piece of property or whatever it may be, borrow money, sell a vehicle, whatever it may be, they have to petition the court and ask the court permission for that. So it's just another court filing that has to get done that could have been avoided if you would have had a will, because you can specify all these things in your will. All right, let's go to the next slide here. Okay. So we talked about intestacy. So again, intestacy is what happens if you do not have a will. So this is what the Florida law says about intestacy. So this is what Florida says about who will get your money when you die. So if when you die, you have a surviving spouse and you have children who are also the children of your spouse, so they're all from that marriage, and your spouse has no other children. So 100% of the children that you both have are both of your children together, then 100% of your assets will pass to your spouse. All right. On the other hand, if you have a surviving spouse and either one of you or your spouse, have children from a prior relationship outside the marriage or before the marriage, then 50% of your assets pass to your spouse and 50% of your assets pass to your descendants. And what do we mean by descendants? We mean children and potentially grandchildren or great-grandchildren if one of your children has predeceased you or died simultaneously. So this surprises some people because a lot of people don't know that. They think, okay, my spouse is just going to inherit everything. It doesn't matter, whether I have children or not, everything's going to go to my spouse. They're surprised to learn that if they have children from a prior relationship, that means the spouse only gets 50%. And even more surprising to a lot of people is if your spouse has children from a different relationship and you don't, then that means, again, that your spouse only gets 50% of your assets and then 50% passes to your children, descendants. All right, so this is what Florida law says if you do not have a will, again. Let's take a look at the next slide here. Okay, so we're still on the topic of intestacy. So again, if you die without a will, intestate. In this case, if you have no surviving spouse, you're not married at the time of your death. On the left there, so if you're not married at the time of your death and you have descendants, meaning children and or grandchildren, then 100% of your assets will pass to your descendants outright, not in trust. Okay, so you might be okay with this. If you're not married at the time of your death, you might be, I'm fine with my children, my descendants, my children getting my property and my assets. That's okay. But you do need to think about the fact that these assets will be passing to those children outright and not in trust, because depending on the ages of your children, they might not be able to really have the maturity or the judgment or knowledge to handle, investing or handling a large amount of money, which potentially this could be, especially if you own your own home and it's paid off, if you have vehicles, you have money in the bank. All of this is going to go to your children outright and not in a trust. So that's another factor to think about. And the last piece here on this slide, if you're not married at the time of your death and you have no descendants, so you have no children or grandchildren, then this is what will happen. 100% of the assets pass to your parents if either one of them is alive. If not, then your assets pass to your siblings, if you have any living siblings. If not, then to your nieces and nephews, again, not in trust. So depending on their ages, that may or may not be okay. If you do not have any surviving nieces and nephews, then the money and assets go to your aunts and uncles, if any, and so on and so forth. So this is Florida law, just the default law of what would happen to your assets. So something to think about, if this is what you would want or not, because this is what would happen if you have no will. All right, let's move on. Okay, so again, overview, what is probate? So probate is a legal process. It's a court case that gets opened, and it is a legal process in which the court will make sure that your will, if any, is legally valid. So it was done correctly according to Florida law, executed correctly, witnessed and notarized correctly, and your debts are paid. If you had valid debts, which creditors have to file a claim in the probate in order to be considered a valid debt. But if that was done properly, then the court needs to make sure that your debts were paid, and then that your assets are distributed according to your will and or Florida law if you don't have a will. So why do people care so much about probate, and why do people want to avoid probate? Why is that such a big topic? Well, that is because probate is bureaucratic. There's a lot of administrative hoops that need to be jumped through, documents that need to get filed. It is costly because, at least in our formal probates, and we'll talk about what that is in a second, you have to hire an attorney. You are required to hire an attorney in a formal probate, which is different from other states, by the way. Some other states like Georgia, you can do it yourself, but here you're required to hire an attorney, and that attorney can take 3% roundabout, depending on how much you own, of your total probate estate value as his or her fee. And on top of that, your personal representative, which again is the person who is in charge of the probate process, the person who's going to be signing all the documents with the attorney, the person who's going to take the action of, securing your home, making sure it's the grass is cut, listing it for sale if they want to sell it, evicting people if there's people living there, selling off your vehicle, making sure your debts are paid, all that stuff. That person can also get paid if they want to for their time, either on an hourly basis, or they can also take a percentage, and it's right around the same, 3%, right around of your total assets. So that can add up as well. And it is time consuming, especially if you don't have a will. It's very time consuming because there's even more documents that need to get filed with the court to kind of prove who your heirs were. And like I referenced earlier, to ask permission to do certain things whenever something needs to get done. So this can be very time consuming. I would say it's about a year on average for a formal probate in Florida, and it can be more. I was involved in one probate where it took a total of 10 years from start to finish, unfortunately for the family. I was hired after year 8 when the children were just like, look, this is ridiculous. We cannot believe this has been going on for so long. We just need to get this wrapped up. And of course, it was litigated, which is part of the problem. And that was an extreme case. But yeah, it took 10 years. I mean, it can take a very, very long time. And your assets really don't get distributed until the end, at least not all of them. So if you want to make sure that your family receives your money and assets right away, you need to take some steps to plan ahead. Okay, so what's so bad about probate? I kind of talked about a lot of this already, but let's kind of review. It can be expensive. As I stated, attorney fees are usually 3% or more. The personal representative fee is 3% or more, or sometimes they bill hourly, depending on their preference. And a lot of times, by the way, if the personal representative is a family member, they will start out telling me, okay, I'm not going to take any compensation. This was my mom or my dad. I'm going to do this for free. I don't want to take compensation. That wouldn't be right. But then as the process goes on, if they feel like they're spending a lot of time on it, which a lot of times they are, they might change their mind about that at the end and decide, you know what? Yeah, I've been doing all the work here while my siblings are sitting back doing nothing, just waiting for me to write them a check. So yeah, I'd like to take some compensation. So that's another factor. It does take time, usually 9 months to 2 years. During the time, the assets or a large part of them will be frozen, so people will not be able to get those assets. Loss of privacy is a concern to a lot of people. Probate is a public process, so interested parties can file, a document and find out who the heirs were. People can go down. You can't do it online, but people who are real nosy can go down to the courthouse and get a copy of your will if they want to. If they want to see what your will said, they can easily just go there, give them the case number, give them your name. They can find out, they can read your entire will, and they can find out everything that's happening in that case. They can find out who will receive what money and what their addresses are. They can find out all of this. Loss of control and intervention of the court. So yeah, if you don't have a will and you're in probate, you really have completely given up control over to the state of Florida as to who's receiving your money. Even if you do have a will, the probate judge is supervising how your will is interpreted. So some people do try to write their own wills, which is usually a big mistake. The probate judge will sit there and read it and say, you know what, this is what I think they meant by this, especially in a case where it's prepared by the person, not by an attorney. Sometimes some of the language can be a little bit confusing or ambiguous or unclear. The judge will have that decision-making power of, this is what the person meant, this is who they wanted to get the money. The probate judge will decide how much probate will cost because they're going to determine how long this will take. Some judges are easier to work with than others. Some of them want more administrative documents filed than others. So you're really allowing the court a lot of intervention and control over your family. In addition to that, and this is a big one that people don't think about a lot, wills cannot help you plan for potential disability. So, and this happens a lot these days, people living longer and longer. If you lived to the point where you become elderly and you develop Alzheimer's or dementia, which is unfortunately pretty common, and you get to the point where you cannot handle your own affairs because of that incapacity, then a will is not going to help you. If you haven't given anybody, like in a power of attorney or a trust, the authority to sign documents for you, execute documents for you, then you could be stuck in a situation where nobody can help you. The will's not going to help you because the will does not take effect until you pass away. So before then, a will does nothing for you. There are other documents that you will need to put into place that will help you get through any period of disability that you may have in the future. All right, so let's move on here. Which brings us to revocable trusts, otherwise known as living trusts, revocable living trusts. It's all the same thing. Basically, it's a type of trust that people use very commonly to avoid or minimize probate. And again, these work together with wills. So they are sort of like a will substitute because they kind of act like a will, but they don't completely replace the will. If you have a revocable living trust, you'll also need a will together with that. The trust will protect your assets from your children's creditors if it's drafted correctly. What that means is we draft it as a spendthrift trust so that after you pass away, it becomes a spendthrift trust, meaning that if your children are, the type of people who spend a lot of money, maybe they have debts, their creditors, so your children's creditors, cannot reach the money and the assets that are held in your trust. Unfortunately, you cannot provide that protection for yourself during your lifetime due to the nature of this type of trust, because you have the right to revoke, amend, modify, or change it at any time, which is great, but you can't have your cake and eat it too. You can't have the type of trust where you can amend, revoke, or modify it at any time and lock up all your assets away from creditors. So this is only a benefit that is for your children and not for you, but it is a nice benefit. Also, a trust can help you avoid a court-managed guardianship over your assets if you become mentally incapacitated. So this is what I was kind of referring to on the prior slide. If you do age to the point where you develop dementia or something like that, where you're unable to make your own decisions and you can't really manage your own finances anymore, if you have a trust, then you'll have a successor trustee who is named in that document who can take over if you ever become incapacitated. and they can just take over the management of all the assets and the property that are owned by that trust. So we don't need the court to come in and do anything. So if you don't have a revocable trust, and maybe you have a will, maybe you don't, either way, if you don't have a trust, your family might need to open a guardianship of the property to get control over your assets. And again, a guardianship, just like probate, it's a court case. So it is a court case where you have to pay a filing fee, which in Florida are kind of high. It's like $400 just for a guardianship case, and it's like another $250 for a mental health case, which is the case in which you establish that the person is incapacitated. And then that's just the beginning. Then you have to be represented by counsel in a guardianship. So you have to pay attorney fees. And not only just in the beginning of the case when you get the case set up and you get appointed as guardian, but on an ongoing every annual basis, you have to file an accounting in these guardianship cases, which the attorney will prepare and file for you, and you have to pay those fees every single year. So that's a really, really nice benefit of a revocable trust, is that they can allow you to avoid a guardianship of the property. You can avoid all of that with a trust. In addition, you can maintain control of your assets throughout your lifetime. So while you're healthy, well, and have capacity to manage your own finances, you maintain control and management over everything in that trust because you're the trustee. So you can invest your property and your assets as you wish. You can sell property, you can buy new property. There's no restrictions on what you can do with the property in the trust. So it's really nice and flexible that way. And you can change the provisions of the trust at any time. So it's very flexible. It allows a seamless transition of management of your assets, like I kind of referenced earlier. So no court involvement. If you do become incapacitated, we don't need to have a court step in. Your successor trustee can just step in and begin and take over from you in a management role. And then when you do pass away, the successor trustee will also step up at that point, if they haven't already, to make sure that your wishes are carried out, that you specified in the trust, and that the people that you said should receive the property when you pass away actually do receive that property, all without court involvement, no probate. This is just done privately. But they are only effective if you actually fund them. And that could be the point that trips people up a lot of the time. They'll come to me and I'll talk to them about these trusts, and they'll say, yeah, this is a great idea. I really like this idea. Let's do it. And we do it. But then I tell them, okay, you've got some homework to do. You have to go ahead and, retitle your bank accounts in the name of the trust. And I give them instructions on how to do that. And then, okay, go ahead and do it. And then they don't do it. So if you don't take that final step of funding the trust, meaning actually putting assets into it, then they don't really do a whole lot for you. They're not going to hurt you, but they're not going to really help you either if you don't take that last step of funding the trust. All right, let's move on. So how do you fund a trust? Okay, so if you come to me and we talk and you decide, yeah, we want to do a revocable living trust, I will handle the real estate for you. So your home and any other real estate and timeshare, if it's deeded timeshare, we will do warranty deeds for you, and I'll draft those, and we will therefore, using the warranty deed, transfer those properties into the name of the trust. Just like if you were to go and sell the property, you would transfer it with a warranty deed to that third party. In this case, you're signing a warranty deed from yourself as grantor to yourself as trustee of the trust. You sign that deed, and then we record it electronically for you with the county, pay that recording fee of like $40, whatever it is, and then it's done. So we do that part for you. Now, the bank accounts and investment accounts, those can take a little bit more time. Usually we'll at least give the clients the option of, hey, this is what you need to do. We can either do it for you or you can do it yourself. But basically it's a form letter that usually somebody has to draft, either us or you, instructing each bank that you bank with, where you have investments, that you want to change the name on the account or the title on the account from your name to the name of the trust. You sign the letter, you put it in snail mail with a copy of the certificate of trust that we give you, which is like a summary of the trust. And then that starts the process. And then usually most of the financial institutions have their own form that they want you to sign off on in addition to this, but we get the ball rolling and then it's done. And then also sometimes if you have a financial advisor, you can just email them a copy of the trust and they can do that for you, and that makes it a little bit easier. Deferred income accounts like IRAs and 401ks, a lot of people have a lot of investments and money in those. Those actually do not get retitled, because if you ever look at your statements, those are not actually in your name. They're in the name of the custodian for the benefit of you. So they actually don't get retitled in the name of the trust. But what you'll do after you sign the trust is you'll update your beneficiary designation forms to coordinate with the trust terms. So you'll probably either name the trust directly, or if you want everything to pass to your adult children without any further trust because they're old enough to handle the money, then you could name them directly, depending on what you want to do. But part of the process that we go through with our clients when they do want a trust is to revisit all the beneficiary designations with them, make sure they're updated, and that they coordinate with the planning that we're doing. That's how you handle those. Same thing with life insurance. The beneficiary designation forms for those life insurance policies should be updated to either pay directly into the trust or, according to what you want to do, maybe to some individuals directly if they're old enough to handle it. And then sometimes we have the trust as a backup provision in case someone predeceases you. But we kind of go through all that because it's very important to revisit all of these things. Okay, doesn't it take a long time to do all this? All right, I'll admit it, this can take some time. This whole process from start to finish can take a little bit of time, but if you do put the time into it now, your family won't have to do it later. And just imagine, some of you have already been through this with some of your family members, maybe your parents, and some of you haven't. But even if you haven't been through it, you can imagine that it is very stressful to be mourning the loss of a family member and at the same time having to go through all of this work and all this administrative process to try to get money moved around. It's almost like a full-time job sometimes, depending on how many bank accounts the person had when they died, how many properties they owned. It can be a full-time job for a year, trying to get everything straightened out and situated if everything wasn't already done beforehand. So drafting and funding a trust is a way of helping your family by taking care of all this for them beforehand so they won't have to do it later. So let's talk about the overview. How does a revocable living trust work? So as an overview, you transfer your assets to this revocable living trust, which you control. So technically, you no longer own anything. It's all owned by the trust. As the trustee, you still have control over all these assets. So you can still buy, sell, and invest everything just like you did before. But since you no longer technically own anything, the courts have nothing to administer after you die, and they have nothing to administer if you become incapacitated. They don't have jurisdiction. It's all in the trust. So it's not handled by the courts. It's handled privately through the trust. So no probate is necessary, and no guardianship needs to be set up for your property later in life. So it's a nice thing. Okay, let's shift gears a little bit. So what about jointly owned property? A lot of times people will come to me and they'll say, you know what, I don't need to worry about anything because I have got all my bank accounts in joint name with one of my children, or maybe two of my children, or I've got this one account with one child and one with another, and I got my house jointly owned with this other person. Maybe it's my sister or my son, I don't know. Happens a lot. And they think they've got it all worked out. But sometimes this can create more problems than it solves. Let's talk about why. So, first of all, problem with joint property very commonly is that it can defeat the objectives of your will. So let's say you come to me, you draft the will, and it says, I have no children, but I want even better example, I have 4 children, but I only, I've got all my accounts titled jointly with one of them, but I want all 4 of them to share equally in my estate. And your will says everything's split 4 ways between each of my 4 children when I pass away. That's all fine and good, but if you have your bank accounts and your investment accounts all owned jointly with one child or 2 children or whatever, then guess what's going to happen when you pass away? That joint owner on those accounts is the person who is going to automatically receive those assets. They're going to automatically become theirs. That bank account automatically becomes theirs when you pass away. So now you're looking at a situation where you're relying on that child to quote unquote do the right thing and make those distributions to their siblings or whoever it's supposed to be. Sometimes that happens, and I'm here to tell you a lot of times it doesn't. And that doesn't mean that your child or whoever is a bad person, whatever that, a lot of times what it is that particular child is often the one who was functioning as the caregiver of the parent for many years, maybe before the parent died. So really and truly, in fairness, that child probably deserves to get a little bit more because they spent so much time. They did a job, basically, that they may or may not have gotten any compensation for. So when the parent finally passes away, the child is sitting there like, look, yeah, I should have these bank accounts kind of compensate me for all the years that I spent taking care of mom or dad when my siblings didn't do anything. Also, another risk, so that's a risk, is that child is not going to turn around and write checks out to their siblings the way that you thought they would or the way that you think they should. Another risk is if you put a savings account or a bank account in joint name with your son or daughter, that will expose that bank account to your son or daughter's creditors. So your son or daughter is going through divorce and they have an ex-spouse who's coming after them for money. That ex-spouse can reach your bank account because technically, if it's jointly owned, it's also your son or daughter's bank account. Even though you might have been the one that put in all the money, contributed all the money, that doesn't matter. If it's jointly owned, it's considered an asset owned by that child along with you. So any creditors they have can come after it. And here's where we've got a number that I was supposed to update from last time and I didn't. I apologize. It says for married couples with a taxable estate over 10.8 million, that's more than double that now because I didn't update the number. So this is referring to the estate tax exemption. Right now, the estate tax exemption is quite high. It's $11.58 million per person, I believe. So let's say it's $23 million per married couple. If you have more money than that, which most of us don't, including myself, then you're going to have a big problem with jointly held property because you're going to have adverse estate tax consequences on that. Most of us don't need to worry about that anymore. Maybe it'll become an issue again in the future. We'll see. Another problem with joint property is that it might cause family discord after your death. And that kind of goes with what I've already said about you're relying on one person to write a check out to other people, which may or may not happen. Of course, that's going to open the door to a lot of discord, a lot of infighting, a lot of people being suspicious of other people. Like, okay, you wrote me a check for this much, but I think you had other money that mom gave you. You know what I mean? So it's really, you could be walking into a hornet's nest. Occasionally it can work the way you think it will, but oftentimes the joint property, joint ownership does not work the way that you want it to. Let's talk about some other documents. Powers of attorney and healthcare surrogates. These documents are very basic, but they are very necessary. One of the reasons for this is that disability is much more likely than an early death. People are always worried about dying young, dying early, and of course it's a tragedy when that happens, but it's far more likely that instead of dying early, that you're going to become disabled due to an accident, due to whatever variety of things that can happen. And so if you do become disabled, you're really going to need these documents. A power of attorney, financial durable power of attorney, allows you to name an attorney in fact or agent for financial related decisions if you're not able to make your own financial decisions. And a durable power of attorney will cover more types of decisions than a trust. So in a durable power of attorney, not only does it cover the right to do things like get into your bank accounts and do banking transactions, but it also allows your agent to speak to your creditors on the phone. So if they need to pay a bill and they need to call and see how much you owe on something, they're enabled to do that. They're empowered to do that. They're also empowered to talk to IRS if there's a tax issue that they need to handle. As you age, if you have income streams like pensions, things like that, they can talk to the pension provider, they can change your address, something that basic that needs to get done. You have to have somebody authorized to sign those documents for you if you get to that point where you're disabled or incapacitated in some way. Going back up, Terry Schiavo, most people remember this very sad case in Florida. God, it was a long time ago now. I want to say it was like late 90s or maybe 2000, where Terry Schiavo, who is healthy, something happened to her, I don't remember, but she ended up in a coma. She did not have a healthcare surrogate in place. She was married, but from what people had said, from what I recall, she was either in the process of getting a divorce or was strongly thinking about filing. I don't know if she had already filed, but whatever it was, she was not divorced yet. So she was still technically married. And so she had her husband on one side fighting for control over her medically. So he wanted to be able to make medical decisions for her. Then she also had her parents on the other side fighting to also make the medical decisions for her and saying, look, she wanted to divorce this guy. We should really be the ones making decisions, not him, because he wanted to take her off life support and they wanted her to stay on. And it went all the way up to the Florida Supreme Court. The case was heavily litigated. Her face was all over the TV. Everybody remembers her as this disabled lady, which is really sad for her. And I'm sure that's not how she wanted to be remembered. If she would have had a designation of healthcare surrogate, this all would have gone far, far differently, because she would have had someone named, either her husband, if that's what she wanted, or her parents, if that's what she wanted, or somebody else named to make these decisions. And she would have had a point person, and that person would have made the decision, consulting with the doctors, whether or not she should be removed from life support. And no one would have had to see her face all over the TV. As far as living will, and I did have quite a few questions about this, so I need to make sure I address it. A living will is not to be confused with will or last will and testament. Last will and testament, otherwise known as will, deals with disposition of property and assets at someone's death. It can also address, preferences regarding burial or cremation and guardians for minor children, things like that. A living will, on the other hand, deals only with end-of-life medical decision-making. So a living will is the document where you're going to specify your preferences regarding whether you would want to be removed from life support if you are basically at the end of your life as determined by two medical doctors. We draft these kind of as a backup to the healthcare surrogate, because the healthcare surrogate document is the one where you're going to name a person to make these medical decisions, including the decision whether to remove you from life support if it ever comes down to that. A living will does not designate any sort of agent, at least the ones I draft. I have them usually separated. Sometimes I combine them with the healthcare surrogate, but the living will is not the part that designates an agent or a surrogate. The living will just states your preferences regarding end-of-life medical decision-making. So it clarifies what your wishes would be in that scenario. But you do still need to have a designation of healthcare surrogate, which would name a person to make those decisions for you. So hopefully I've cleared it up. There's quite a bit of difference between a living will and a will. I wanted to mention, because a while ago this was more of an issue because people weren't familiar with Hipaa. These days a lot of people are familiar with Hipaa, but I still get people that come in that have documents that were done like over 10 years ago or even over 20 years ago or whatever, and they think they're covered. Like, hey, I signed these powers of attorney or healthcare surrogates. I signed them back in 2010. I'm sure they're still fine. Well, the problem is the statutes got updated for both the powers of attorney and healthcare surrogates in 2011, 2012, somewhere around there in Florida. So basically, the whole statute got revamped. So if your documents are older, they may not contain all the provisions that we really need to have in those documents. They need to be updated. A lot of the older documents don't cover Hipaa, which is very important. You may or may not be familiar with Hipaa. It's the Portability and Privacy Act relating to healthcare. So if you don't specifically authorize your healthcare surrogate to be able to access your medical records according to Hipaa, even if the person is correctly named as healthcare surrogate, if you didn't waive the privacy rights relating to Hipaa, then that person will not be able to get your medical records, which is kind of silly. So you need to make sure that your forms are updated, your healthcare surrogate's updated to include a waiver of those Hipaa rights and allowing your agent access to your medical records. And so the statute changed significantly in 2015. If you have older documents, you really need to kind of revisit them and make sure that they're up to date. And please, please, please do not rely on forms that you may have signed in a hospital. If you went into the hospital for surgery, the hospitals have standard forms that they'll give you and tell you to sign. If they don't know if they don't know that you have a healthcare surrogate, or if you don't have one, they'll make you sign these like 1 or 2 page forms. Those are not comprehensive forms. Please don't rely on those. They do not contain everything that you might potentially need. Out-of-state property. That's another thing that people are often surprised by. If you own real estate in another state, including timeshare, if it is deeded timeshare, meaning the kind of timeshare where you got a warranty deed that basically looks just like real estate. These days, sometimes the modern timeshare, people have these points instead of the actual deeded property. So I'm not necessarily talking about that. I'm talking about the deeded timeshare. Any sort of real estate that has a warranty deed with it, which is most real estate. If you own that real estate in another state in your name, then your family might have to go through probate twice when you pass away. Once in Florida and once in that other state where that property is. And that's a big pain because usually that's going to involve not one, but two attorneys because they've got to be licensed in whatever state that is. So like, for example, me, I'm licensed in Florida and Georgia, but I'm not licensed in New York or California or anywhere else. So if I'm handling your probate here and you've got property up in Michigan or something, I'm not going to be able to handle that. We're going to have to find an attorney who handles probate up in Michigan. So you're going to have to pay two sets of attorney's fees, 2 sets of court filing fees to open the probate cases. So this is definitely something that you'll want to avoid because it's so expensive and it's unnecessary. So one way to avoid it is, again, with the revocable living trust. You transfer the title on your vacation home, your second home, your investment property in that other state over to your revocable trust. Then you can avoid that second probate and the first probate as well if you have all your property in it. You can also do this with an LLC. So an LLC can be a good alternative to revocable trusts. It kind of can accomplish the same thing. I'm not going to get into that in detail, but that can also be like a nice alternative, at least for properties. If you had a bunch of investment properties, that can work as well to avoid probate. And it is called ancillary probate. That's second probate. So it's like an offshoot of the first one, but it's basically a whole second probate. I do them all the time here in Florida for people who own vacation homes here, who basically lived in another state but just had a second home here or a timeshare here. I do this ancillary probates all the time. And like I said, don't forget about timeshare. A lot of people own it, and it's treated just like any other property. Okay, so let's get this done today, and I'm going to warn you about some traps for the unwary. One of them is if you try to do your will yourself. Yes, I know I'm biased because this is what I do, but I will tell you, a lot of times people come in and their family member maybe has drafted a will with LegalZoom or whatever it is, or maybe they just typed it up themselves because, they're a smart person, they can write and they feel like they can do this as long as it's notarized. I'm here to tell you 9 times out of 10, they would have been better off with nothing. They would have been better off with intestacy than they would have been with this will, because the will might not have been executed properly because there's a lot of different things you have to do. It's not as simple as signing and getting it notarized. There's a whole extra layer of authentication that you have to do with a will that we obviously do for you if you come to us. But if that's not done, then I have to take extra steps after someone dies to authenticate that will, which means I either have to track down witnesses who may or may not be alive, or I've got to track down a disinterested person who's familiar with your signature, who can swear an oath or is willing to swear an oath that was your signature. It's a whole bunch of research and extra steps. And of course, I get paid for my time in trying to do that. In addition, people oftentimes will mess things up as far as who's going to get the property. They don't put, a second person. So if the first person they named is deceased, or even more common, if that first person doesn't want or need the money, like I referenced earlier, if somebody's receiving benefits, like if they're in a nursing home or assisted living, they're getting Medicaid or VA benefits, if they inherit a whole bunch of money, that's going to disqualify them from benefits. So that's going to mess up everything they're trying to do. Or if you've got a child maybe that has special needs, you don't want to just give money to that child because most of the time that child is receiving benefits, and you don't want to drop a whole bunch of money on them because A, that child probably doesn't have the skills necessary to handle investment of that money and management of that money, and B, that's going to disqualify them from benefits for a certain period of time. So you don't want to do that. So we would draft something within the terms of your will or trust called a special needs trust or a supplemental needs trust. Very, very important if you have a disabled child or a disabled family member that you want to provide for. So if you come to us, we charge flat fees for our wills and trusts. So I don't charge hourly for these type of things. So I'll quote you a flat fee. We do our initial consults for free. So I'll talk to you for an hour. These days we do it all on Zoom. But I like it. I feel like it works. I can see people, they can see me, so it's easy to communicate. We talk for an hour. I quote you a flat fee. If you don't want to go forward, that's okay. We don't charge you for that hour. That one flat fee will give you and your loved ones peace of mind for many, many years. After that, it's just as simple as kind of taking a look back at the documents every 2 to 5 years, just to make sure that everything's still the way that you want it. The people that you named are still the people you want to name. The money's going to the places that you want it to go. And if you have a simple update, you just come back to me. We do an amendment or a codicil, and it's not a whole lot of money to do that usually if it's a simple change. And then you have peace of mind, and your family has peace of mind. So that's it. I hope that you guys enjoyed the presentation, and I'm looking forward to answering your questions.
We're going to have a brief intermission to review the questions that have come in, and we'll return in just a minute.
Few good questions. So I'd like to answer these questions as best I can and as many of them as I can. Probably can't get to all of them, but I'm going to pick a few because I have some that are the same questions, so I need to make sure I address them. So I got the question, can you avoid probate with a will? What else do you have to make sure you have set up? Okay, so you cannot avoid probate with a will. You can avoid probate with a trust as long as you have retitled all your assets into the trust. Therefore, there's nothing left to put through probate. But a will not avoid probate. A will just make probate easier if it's done correctly. So if you have done a will, you can, first of all, name whoever you want as your personal representative. And as long as that person is qualified, meaning they don't have a felony on their record, et cetera, and there's no reason that they would. And also, they have to be either a Florida resident or a blood relative of the first degree. So, and that encompasses most relatives, by the way. I think that it includes parents, siblings, aunts and uncles. I think it even includes cousins. I'll have to double check. But as long as it's either a Florida resident or a blood relative of the first degree, that person that you named can be the personal representative. So that's good. You don't have multiple people trying to be the personal representative. And you can also make probate easier by authorizing your personal representative to do all the things they need to do in terms of the will, like selling property, mortgaging, borrowing, liquidating other things, everything they need to do. You can authorize that under the will instead of them having to go to the court every single time and filing petitions for everything they need to do. But a will does not avoid probate, only a trust does. Okay. So why do you need a trust and a will at the same time? A good question, because I realize I said that, but I didn't really explain that. So here's what that is. So as I said, when you do a revocable living trust, you need to fund it, which means you need to move your assets from your name into the name of the trust. And there's a way to do that with almost every type of asset. And we can help you with a lot of that. Some of that, most folks want to handle on their own rather than paying me to do it. Occasionally, they'll want to pay me to do everything. Usually there's a little bit of homework for the client to do, but I do give them instructions on how to do it. However, people are human, mistakes get made, and oftentimes there's like one or two things that get left out of the trust that are still sitting in that person's name when they pass away. That's why you need the will, because what the will says is, okay, any asset or property that I own as of my date of death in my name will go to the trustee of my trust. And that way everything is poured into the trust. So we call them pour over wills. That's what they call those type of wills that go together with a trust, pour over will. So we do it sort of as a cleanup back up to the trust. It is a different type of will than you would otherwise have, but you do need both of them just to make sure that everything's covered. However, if you do a trust, as I say to my clients all the time, you just need to make sure that everything's already in the trust. Our goal is to get everything in the trust by the time you pass away, so that we don't have to clean it up. We don't have to do any sort of probate. Okay. Does a power of attorney take your power away as soon as it's executed and give it to another person? Okay, no. But this does bring up a good point. So no, a power of attorney does not take away your power to make decisions for yourself as soon as you sign it. You can still sign documents and pay bills and, file a tax return and apply for, all the things that you might want to do, you can still do. However, these days, especially as of, I want to say like 10 years ago, maybe 9 years ago, when the statute got revamped, no longer can we do these documents that are used to be called springing powers of attorney. Springing powers of attorney are a type of power of attorney that we used to be able to do that would only take effect when the person signing it became incapacitated. We can't do those anymore. As of 9 or 10 years ago, they're all effective upon signing. So what that means is as soon as you sign that durable power of attorney, the person you named as agent has power as of day one, as soon as you signed it, to do things like banking transactions and paying your bills and filing tax returns for you and signing your name to things, okay? So it is a very powerful document that you need to be kind of careful with. So if you're naming someone, usually if you name your spouse, people aren't really concerned about that. But if you're naming your brother or sister or adult child or somebody else like a friend, you might want to be a little bit careful about turning over the document until a little bit later when you need it. So a lot of times people in those situations, I'll offer to them that I can keep that original document in my files and only release it over to your agent when I get proof from a medical doctor that you're incapacitated, or when you yourself request it from me in writing, then I'll turn it over to you. But, sometimes you need to be a little bit careful with these durable powers of attorney because they do entail a lot of power for the person that you named. So that's a good question. Okay. Public records concerns. Revocable living trust still public. Okay. Revocable living trusts are not public. They are a private document. So they do not get filed with the county. Nobody can view them unless they're somehow involved in trust litigation or something like that. But they are not a public document. When someone dies, I don't file them anywhere with the state or the county. So that's better than a will, because wills do get filed with the county. And like I said, any nosy neighbor that you might have can go in and get a copy of that will and see what it says. All right. Not so with a trust. It is not public. Can you sell property that has become part of a revocable living trust? Yes, you can. Regarding a timeshare, if it is willed to a family member, can they just refuse to accept it? Yes, they can. Anyone can refuse to accept any property or asset that they are given in a will if they want to. It's called a disclaimer or a renunciation. It's a document that an attorney can draft for them, very simple one-page document they draft saying, no, I don't want this. And basically, it passes then according to what the will says, if there is a will, or according to what Florida law says, if there is no will. So if the will says, I'm giving this property to my sister or her descendants, then if sister disclaims and says, I don't want this property, then her descendants, meaning her children, will get the property. And there's nothing she can do. She can't state or say who gets the property. It passes according to the terms of the will or according to Florida law. Okay, let me go back here to my other questions. What advice? Okay. What advice do you have for homeowners with no living children to pass assets to upon death? Well, if you have no living children, then you really want to think about who you want to receive your assets upon your passing, because maybe you have siblings or parents, maybe you don't have siblings or parents who are alive. And if you do, you have to think, do I want my parents to get my money? Do they need my money? Do I want my siblings to get my money? Do they need my money? Or would I rather give it to a charity or to my best friend who's always there for me, or whoever? It's really up to you. If you don't make that decision, then again, Florida law will make that decision for you. I'm not sure. Yeah, so hopefully I answered that question. This person said they have a half brother and sister. Would they be entitled to any of my benefits when I pass away? Yes. So under Florida law, siblings of the half blood is what they used to call half blood, that they are considered heirs just like anybody else. They're considered just to be like full blood brothers and sisters. So yes, they could inherit your property for sure. Not step siblings or step children. So unless you've like, for example, if you adopted your stepchild, then okay, yes, then they're treated like any other child. But if they're just a stepchild, stepbrother, whatever, that is not considered someone who would be your heir. So unless you wrote them into your will, they're not going to, by default, receive anything when you pass away. Just FYI. Another question, do you have bilingual speaking staff? And actually, yes, I do. My assistant speaks Spanish, Portuguese, and French. She is brilliant. And I have another person that I'm thinking of hiring who also speaks Spanish, I'm happy to say. So yes, we do have bilingual speaking staff. Does Florida recognize a will that was created in another state? So the answer is technically yes. Every state has to recognize a will that was executed correctly according to the terms of law of another state of this country. That being said, every state has different laws when it comes to probate and different statutes and different things that are required. So I couldn't sit here and give you a rundown of all 50 states and what the differences are between the laws of each one, but I do know the laws are quite different from state to state. So like I had kind of referenced earlier, Georgia is a lot more informal than Florida. In my opinion, it's a much easier process to go through. You could do it yourself if you wanted to, offer a will for probate, and you don't have to hire an attorney. Whereas here you do. You have to hire an attorney. Can't do it yourself unless you have less than $75,000 worth of assets, which we didn't really get into in this presentation, but that's called summary probate, and that those you can do yourself. But very often people still hire an attorney for those because they don't really know how to do it. So they end up hiring an attorney anyway. But laws are very different from state to state with regard to probate matters. So it is important to, if you do move to another state, to kind of meet with an attorney just to revisit and review the documents and make sure that there's nothing missing that needs to be in those documents to comply with the laws of the new state. Because even if the will is considered valid, there might be something missing. So that there might be something you have to do in a probate, or, like I mentioned, here you have to specifically empower your personal representative to sell property if you want them to be able to do that. Maybe that's not required in another state. So if you don't have that and you pass away here, then you're going to have to do extra work on that piece of it. Something like bond, like here, a bond, depending on what county you live in. For some reason, Pinellas and Hillsborough and the counties over on that coast really love bond, and they always require a bond in a probate proceeding, which is basically like an insurance policy that the personal representative has to buy. Whereas here in Orange, we don't usually, it depends on the amount of assets and what the situation is. It's up to the judge, but we don't usually require it. And so in all the wills, I'll waive that provision just in case, the judge decides they might want a bond. I waive it so that we don't have to do that. But maybe other states don't require that. So if you have a will from like Connecticut or something, maybe you didn't waive bond and then you pass away here, you might not be able to avoid the purchase of the bond. So that's just a random example of something that could vary from state to state. So you really should get your documents looked at again if you moved here from another state. Let me see, another question. I have a will. Oh, this is actually a really interesting question. I have a will, but I wanted to change my executor, so I crossed through their name with ink. Does that void my will? This is like a law school question. This is a really good question. So it depends. I don't really know, but that's up to the judge. So I'm very, very careful about wills as far as execution and writing. Please do not write on your will. Please do not cross through things, because the judge could definitely look at that and say, you know what, no, this isn't right. Because you have to think about why would they do that? Because somebody else could have come in behind you and taken a pen and crossed through it and written it and said it was you. You know what I mean? So this is why it could very well invalidate your will. And the whole thing too, not just that paragraph. And that's really a decision for the judge that could be argued by counsel. I know in Georgia that it probably would be, your whole will would be revoked if you struck through something with a pen and try to write on something. So definitely do not do that. If you want to make a change to your will, you need to do a codicil. That's what they call amendments to wills. They're called codicils, or just do a new will. And of course, we are happy to help you with that. If you just need to change one thing, it's not going to be a huge fee to do that. I know I had some more questions. Let me go back here. Okay, this person's saying, if I have a will, does that supersede probate? Does probate only affect those who do not have a will? No. If you have a will, you still will have to go through probate. It just makes the process easier and clarifies it and clarifies who should receive what and who should be the personal representative, which, by the way, is also another name for executor. That's the same thing. Somebody brought that up in a question. That's the same thing. So no, it does not, a will does not allow you to avoid probate, but a trust does. All right, I think I've answered most of them. So, and I think somebody asked for my contact info, and I realized when I ended the presentation, I ended on a blank slide. So now we're pulled back up to the cover page of the presentation. You should be seeing this. This has my phone number right here and my email address. So please feel free to call my office, this phone number right here, 407-494-6701, or you can email me. The email address that's listed there at your screen, mary@thecapfirm.com. And I would be happy to meet with you. Again, I do free initial 1-hour consults. Be happy to answer any questions you have. I'm not going to quote any fees to anybody today, obviously, because I have to know a little bit more detail about your needs. I have to talk to you first before I can quote you a fee. But I do all this on flat fee basis. And again, I do free 1-hour consults. So if you don't like my fee, you don't have to go forward. I really appreciate your time this morning. It's been really fun. I always love giving these presentations. Please call my office if you have any questions, or if you'd like to book an appointment, please call us. Have a great day.
Thank you so much, Mary. This concludes our presentation this morning. Check your inboxes for an email containing a link to today's recording, and thank you all again for joining us. Enjoy the rest of your day.